Good morning friends, welcome to Sarat Chandra IAS Academy daily current affairs analysis for the date of 6th May 2022. So the topics for the day or the first topic is about Delimitation Commission, which released its final order for the Jammu and Kashmir. Second topic is about the Sedition Act and its constitutional validity. Third topic is about the reforms needed in the World Health Organization. Fourth topic is about the Collegium System. Fifth topic is reforms needed in the GST Regime. Okay, so coming to the first topic, that is Delimitation Commission, which released its final order for the Jammu and Kashmir. So the context is its Delimitation Commission has released a final order for the delimitation of constituencies in Jammu and Kashmir, which provided for 43 seats to Jammu and 47 seats for the Kashmir region. Okay, so what is the relevance of this particular topic for the exam is the finalization of the constituencies. This will pave a way for the holding assembly elections in Union Territory. We all know that since the Jammu Kashmir has been made Union Territory, the election has not been yet conducted. So after this delimitation exercise, elections will be conducted. Okay, then this, so it will clear the way to conduct the elections. This will also give the powers in the valley to exercise their constitutional right to vote. So it is nothing but democracy comeback democracy in the Jammu Kashmir, and it will also help in integrating the Jammu Kashmir region into the India, into the main India. So by which we can achieve Ek Bharat Akhanda Bharat concept. Okay, Ek Bharat Akhanda Bharat concept can be achieved by integrating the Jammu Kashmir into the mainland. Okay, this particular delimitation process also, not the delimitation process exactly, the democratic elections which have been conducted which are going to be conducted in Jammu Kashmir will help it to integrate Jammu Kashmir into the Indian mainland. Okay, what is the delimitation? Delimitation is nothing but, okay, delimitation concept is, if suppose this is a state, then it is divided into constituencies. If suppose there is a state, it is divided into number of constituencies. So basing upon the population, the size of the constituency is decided basing upon the population. If the population is less, then the size will be more. If the population is more, the size of the constituency is less. Imagine, for example, in this example, say for every 1 lakh there is a constituency. So this area will consist of 1 lakh population, here also 1 lakh population, here 1 lakh, here 1 lakh. So like that, basing upon the population, okay, in proportion to the population, the area, the state or the any particular area is divided into constituencies, so that each area is represented by one member, whether it is MLA or MP. So this process is known as delimitation. It is an act of defining the boundaries or the limits of the territorial constituencies to represent the population changes. Next, so this process is done repeatedly. Why? Because because the population figures change. So that's the reason why the delimitation will also be done repeatedly. Okay, so to ensure that what is the purpose? That is to ensure that all parts are okay. So to ensure the population is represented equally, we have to delimit the constituencies time and again. Next, geographical areas have to be divided fairly, so that no political party gains the edge over another in an election. Okay, so the geographical the division of a state into the constituencies shall not encourage any particular shall not help any particular political party in gaining the votes. Next, also to adapt the value of one vote, one value. Okay, philosophy. Every vote, each vote must have the same value. That is the philosophy behind one vote, one value. What is the procedure? First of all, the power to delimit. The final power to delimit is in the hands of Parliament. Okay, so that's the reason why after every census, the Delimitation Act under Article 82 of the Constitution, the power of delimitation is given to the Parliament. Accordingly, the Delimitation Act is passed by the Parliament after each census. Okay, each census under Article 170 states are divided into territorial constituencies according to the Delimitation Act after each census. Next, this Union government will establish a delimitation commission Okay, after then the president conducted first delimitation exercise in 1950-51. Okay, so the delimitation commission act has passed in 1952. So several times, like 52, 62, 72, 2002 delimitation commissions were established 4 times. Okay, now after 1981 and 1991 census, there was no delimitation. Okay, right. Here you see 2002. Okay, here you are seeing 2002, but in the very next statement they are saying that after 91 census there is no delimitation. Okay, so the relation is like this. So after 1972, okay, after 1972 what happened is there was the opposition from the South Indian states, particularly the South Indian states, because day by day in the country, if you see, the South Indian states are losing the number of seats in parliament because of the delimitation exercise, because they are, South Indian states are following strict population measures. So because of following the strict population measures, the ratio of population in the southern part of the country is decreasing and the ratio of the population in the northern part is increasing, by which in the parliament more number of seats are going to the North India and less number of seats are coming to the South India. So this is almost like encouraging the population growth. So in order to have more number of seats in parliament, we have to encourage the population growth. So to defend that, so and in order to support the population measures taken by Southern India, so it is decided that the number of seats from 1972 will be freezed. Okay, okay, and it will continue only after 2026. Why? Because 2026 is regarded as the stabilization year in our population. Okay, it is expected to be our population is expected to be stabilized after 2026. Okay, but here in 2002 the number of seats given to a state were not changed, but within the state delimitation has been conducted according to the population changes within the state. So that's the reason why 2002 delimitation has been mentioned here. But do remember, in 2002 there was no change in the number of seats for a particular state. Only within the states the constituencies were remodeled or delimited. Next, the President of India, as I said, will appoint the delimitation commission. So the function of it is, it collaborates with the Election Commission of India about the constituencies. Next, what is the composition of this commission? Former Supreme Court judge will be there, Chief Electoral Officer, election commissioners from that particular state. Okay, and the functions are to calculate the number of constituencies and their boundaries, and to locate, set aside SCs and STs in areas where the populations are subsequently large, because they may be get the reserved seats. In the event of disagreement among the commission members, majority opinion. Who are the commission members? Former Supreme Court Justice, Chief Electoral Officer, Election Commission from each state. So in India, Delimitation Commission is a very powerful organization because whose decisions have legal weight and cannot be challenged in the court. Right. Now, what is the status as of now? In 2009, 499 out of 543 parliamentary constituencies were defined for the first time. Except Jammu Kashmir and so states mentioned here, this affected Delhi, Puducherry and all states except JK. Next, delimitation challenges are also there. That is, states are unconcerned about the population management, may find themselves with more seats in parliament, right? So that's why, as I said just now, this is against the family planning. So means delimitation process is in a way encouraging the population growth, because only if population of a state increases, the number of seats for the state increases. So indirectly they are encouraging the population growth. So the southern states that are advocated for family planning are losing the seats. Okay, that's why seats reduced. So that's the reason why delimitation was done in 2008 based on 2001 census. However, total number of seats in assemblies and parliament were not modified from 1971 census. Number of Lok Sabha and Rajya Sabha seats also been limited by the constitution to 540 and 250 respectively. Okay, the maximum number in Lok Sabha is 550, maximum number in Rajya Sabha is 250. As of now, this is maximum. As of now, the running number is 545 and 245. Next, what is the procedure that should be followed So before 2026, as I said, 2026 is regarded as a stabilizing year in our population. National consensus exercise should be initiated to resolve the consensus. So weightage given to the population in financial commission could also be reduced from 10 to 5. Why? Because reduction has to be encouraged. That's the reason why weightage for the population has been decreased in getting the funds, allocating the funds to the states by the finance commission. What are the steps to follow? Although restrictions on number of seats should be lifted after 2001, it was delayed till 2026, as I said. Why? Because on the grounds that the country would have reached the consistent population growth rate. Stabilization of population occurs in 2026. Next, second topic of the day is constitutional validity of the Sedition Act. Okay, so the context is, while hearing a plea challenging the constitutional validity of Sedition Act, Supreme Court is examining whether it should refer the matter to the higher bench or not. So, as we know that we got independence, we are going to celebrate our Amrit Mahotsav, and still we have section 124 in our IPC. Okay, we have section 124 of IPC, which was brought during the Britishers period. So in those days, Britishers used this particular section to suppress the nationalist voice and also suppress the opposition against the colonial government. So in the past few decades, it is abused that government is misusing the power which was given to it under section 124 IPC and also violating the fundamental rights of the people, it is said that critics say that some of them argue that even the constructive criticism is also regarded as sedition. Okay, so if you see the history of the sedition law in India, it was enacted by 17th century in England when MPs believed that only positive government beliefs should exist. This was drafted in British India in 1837, okay, by Thomas Macaulay. So it was deleted when IPC was implemented in 1860. But however, this section 124A of IPC now makes sedition a felony. Okay, I mean a crime. So today's the stand of sedition law is, it defines what is the definition of the sedition. Okay, definition of the sedition includes, if any individual who by his words, whether it is the words can be spoken or written, or by signs or by visual representation or otherwise, brings or seeks to bring into hatred or contempt which incites the disaffection towards the government. This constituted by law in India. Okay, so a government which is constituted by law in India, if there is any disaffection towards the government encouraged by any particular speech or writings or signs or whatever, then that comes under the sedition. Definition of sedition under the section 124A of IPC. Disaffection encompasses all feelings of hostility and disloyalty. So comments that do not incite or attempt any hatred shall not be considered as offence. The penalty of sedition is a non-bailable offence. Yes. First of all, it is a non-bailable offence. The punishment can be from 3 years to life sentence. Okay, so the people charged under this statute prohibited from working for constitution. So if you are like charged or accused of sedition, then you cannot work under the government. You cannot do the government job. Okay, they are forced to leave without their passports and must appear in court whenever they are summoned. Okay, so the punishment is very severe. On one side, they cannot do any job under the government, and on the other side, their passports are restricted and they have to appear in the court whenever they are summoned. So what is the importance of the sedition law? Reasonable restrictions. So they want to place reasonable restrictions on the people's fundamental rights. Okay, so in Article 19(2) can be put on this right at any time to guarantee that it is exercised responsibly and equally by all the citizens. Sedition law aids the government in battling the So sedition law, so the supporters of the sedition law says that it helps the government in fighting anti-national, separatist or terrorist elements, and also it helps in maintaining the state stability, right? So protected the elected government from the violent and illegal attempts to throw it, right? So it encourages the state stability. Now what are the problems with the sedition law? First, it is a colonial era law. Okay, so mostly it was used against the Indians by the Britishers in order to suppress the nationalist movement. So liberation fighters, so the freedom fighters like Tilak, Gandhi, Nehru, Bhagat Singh were convicted of the seditious speeches. So as a result, there was this particular seditious law has been many times misused during the colonial era. The Constituent Assembly, so after the independence, the Constituent Assembly took the position that sedition should not be included in the Constitution. That's why they did not include it in the Constitution. So members were more concerned that it would restrict the freedom of speech and expression, which was guaranteed under Article 19. So they claim that sedition statute may be used as weapon to restrict the people's constitutionally protected right to protest. So the sedition statute is not there in Constitution. So Constitution is giving more right to the fundamental rights, more weightage to the fundamental rights. So but in 1962, Kedarnath Singh versus State of Bihar, in this case, Supreme Court confined that the definition of sedition is to act that, what are the acts comes under sedition is acts which involve the intention or inclination to cause the commotion, disturbance of law and order, or instigation to violence. So as a result, rising sedition accuses against academics, attorneys, social activists, students violates the Supreme Court mandate. So if you see, India is increasingly being referred to as an elected autocracy, okay, owing its permeated application of sedition statute. So as if sedition statute is used frequently by the government misusing its power, then it may unnecessarily create the negative forces in the society. Okay, so yeah, if you see the recent developments, the Supreme Court shielded a political leader and 6 leading journalists from arrest in Feb 2021 after multiple sedition affairs have been filed against them for allegedly tweeting and disseminating the substantiated news. Okay, and while protecting 2 Telugu news outlets from coercion by Andhra Pradesh government in 2021, Supreme Court emphasized the importance of defining the limits of sedition. Okay, and next in again July 2021, petition was submitted requesting the sedition law to be reconsidered. That means government has to consider or make necessary changes in order to make it more suitable for the society, protecting, or I can't say protect, but balancing between the right to information on one side, right to speech on other side, and right to privacy on the third side. So next, this particular statute of this particular statute criminalize the expression based on the unconstitutionally vague definitions of disaffection towards the government. Means there is no clear definition of what is sedition and what is not. So disaffection towards the government is regarded as the opposition, but in reality it is a just unreasonable restriction on the fundamental right of free and expression guaranteed under Article 1A, and causes the constitutionally impermissible chilling effect on speech. Okay. Next, coming to the what are the steps ahead, what to do with this Article 124A. If you see this section under IPC, it can be used to fight anti-national, separatist, terrorists elements. However, in a healthy democracy, people must have every choice, every way possible in order to criticize the government, because they have decent and criticism of the government are necessary. Why? In the public discourse, because it is a healthy democracy. In the healthy democracy, people must given all the voice. People's voice is given higher importance. There should not be any insight of dissent. So higher courts should use these supervisory responsibilities to educate the magistrates and police about this free expression. Okay, so the judiciary and the system, police system must give good importance to the free expression, and the concept of sedition should be restricted to exclusively problems like the problems which disturb the integrity and sovereignty. Okay, as far as possible, the concept of sedition has to be kept only for the topics of territorial integrity and sovereignty. So where only these are disturbed, then you have to bring 124A of IPC into the picture. So we know that the India is the world's largest democracy, and freedom of speech and expression is necessary for the Indian democracy. That's why sedition should not be applied to any word or thinking that is contrary to the. So if suppose a government, if someone contraries or criticizes the government policy, you cannot just like that apply the sedition case on that particular person. So it has to be used in very rare cases, only in case of like whether it is disturbing the integrity and sovereignty of the country. So that's why the term sedition is highly complicated and should be used with very caution, right? If it is having a cannon, that should not be used to shoot a mouse. Okay, it arsenal requires the cannons usually. So here he compared the law of sedition with the cannon. Okay, law of sedition is compared with the cannon. That's saying that you cannot shoot a mouse with cannon, but at the same time the availability means the requirement of cannons is also there in the country. Okay, next, the third news is about the reforms needed in the WHO, that is World Health Organization. So according to this estimates, India has the highest death toll due to the COVID-19 in the entire world. But however, WHO estimates says that at least 47 lakh people died in India in 20 and 21 due to the COVID-19. Okay, these figures are in contrast. So they said almost highest death 47 lakhs, highest death 47 lakh. But if you see the Indian figures, only 4.1 there it is 47, here it is 4.8, exactly 10%. India is claiming 10% of what WHO says. Okay, so the figures set by the WHO is 47 lakhs, which is absolutely in contrast with the government figure, that is 4.8 lakhs. Okay, so WHO is saying 47 lakhs have been died in India, whereas government is showing only 4.8 lakhs. However, there have been concerns raised in the past regarding the management and release of information by WHO. So even in the past, the information by the WHO many times was not exactly true. Okay, so the issues have been raised for the improper handling of the pandemic in the initial months. Alright, no, so reforms have to be done in WHO, where the statistics and everything has to be, outcomes have to be real and true. Okay, if you see WHO, it has been established in 1948 and its headquarters is in Geneva. It has 194 members, 6 regional offices. It's an intergovernment organization. So generally it collaborates with all the health ministers of the country. So it will take on into global health issues and research, establishing norms and standards. Okay, all the sort of things, health related issues at global level. Okay, so it began its operations in 1948, April 7th. Now if you see the relation between India and WHO, so in 1948 itself, in the very beginning, India became the member of WHO. So New Delhi has also one of the regional office of WHO of Southeast Asia. If you see smallpox, in 1967, India accounted roughly 65% of the cases of smallpox worldwide. Okay, so that's the reason why we need the good support of WHO. So WHO initiated the intensified smallpox eradication program in 1967, by which smallpox is almost reduced, okay, and eradicated in 1977. So thanks to the joint effort of Indian government as well as WHO. So that's the relevant of WHO. Okay, what are the problems faced by the WHO? If you see the problems within the WHO, first of all, COVID-19 epidemic has brought WHO's operation into sharp focus. Everyone was more concentrating on WHO much now so than pre-COVID-19. So organization has been center of so many debates, because so many debates have been done on WHO, the way it handled the pandemic. So there is dereliction of the duty. So some critics argued or accused that there is dereliction of duty. Okay, so siding with Chinese government and cover up of the outbreak, delaying the proclamation, and so on has been. So there are the blames on WHO functioning. Due to the growing number of but we cannot totally keep aside the WHO because of the growing number of multilateral health activities and also PPP methods, NGOs. So WHO's ability to coordinate the global public, there has to be coordination among the countries, there has to be coordination among the other channels, other groups. So this WHO will definitely has the ability to coordinate with the global public health efforts, and also increase the number of parties, and global health governance will be efficient in when a global level health facility like WHO is there. Okay, so the lack of coordination or unclear priority among many actors has left the system ineffective. So if you increase the coordination, if you make the priorities clear, then this body will serve for the day, okay, will be suitable for the day. So, and if you see the more points, WHO's ability to define the health care priorities is being restricted, hampered by the diminishing budgetary contributions. Okay, so as many bodies face the budgetary contribution, even the WHO is also facing the same problem. For the variety of reasons, WHO, the credibility has been decreasing day by day. The key problem is data sharing, particularly of COVID. So the data is not much relevant. Okay, so it is only relying on Chinese government data. Okay, not any other groups. Like its predecessor, the present epidemic highlights need the IHR. China management of outbreak, for example, raises concerns about the compliance of IHR 2005. Right. So IHR's lack of enforcement mechanism is one main reason for the non-functioning of this. And also, despite being the signatory of IHR, the present epidemic demonstrates that the many nations developing lacked, so particularly health capacities. Many nations are lacking the health capacities. So WHO has to come forward, take all necessary steps in order to increase the health capacities in many countries. Okay, so WHO's lack of visionary leadership, transnational cooperation, pharmaceutical companies frequently sway the organization's judgment on global health solutions. Member states, particularly the funders of WHO, have shown lack of political will and vision. Okay, so if you see, the WHO has taken some recent initiatives to improve its own efficiency. So it established an independent panel for the pandemic preparedness and response, IPPR, to access the global response to the coronavirus pandemic. Okay, so these are the important points of IPPR, right? So IPPR follows the landmark resolution on COVID-19, and also President Trump publicly informed the UN of his intention to remove the US from WHO. Okay, on the other hand, stated his intention to return in January 21 and signed an executive order to that effect shortly after his inauguration. So WHO delegation traveled to China to look into the origins of COVID-19, which was supposedly discovered at Wuhan Virology Institute. The findings were released in mid-March. So in February 2021, WHO Director General Tedros Adhanom Ghebreyesus praised the Prime Minister Narendra Modi's dedication to vaccination, equity and sharing of COVID-19 over the 16 countries. Okay, so this is a proud moment for India because we shared vaccines with over 60 countries, hoping, okay. Okay, the next news is about the Collegium System. Collegium System is used to appoint the judges of Supreme Court. So here, recently, two names have been suggested by the Collegium System: Justice Sudhanshu Dhulia and Justice Jamshed Burjor Pardiwala. So to be the recommended as the judges of the Supreme Court. Okay. So if you see the relevance of these particular news, this holds prime significance as Justice Pardiwala is also in line to become the Chief Justice of India after the retirement of Narasimha in May 2028. So also the government has been demanding to introduce reforms in the judicial appointment process, wherein it has demanded that the executive role in the appointment is. Okay. So government earlier attempted to introduce the concept of NJAC, National Judicial Appointments Commission, through which there must be a role of executive also in appointing the judges of Supreme Court. But however, one judgment of the Supreme Court declared this NJAC as unconstitutional and made it invalidated, and it continued the collegium system. Okay, the collegium system refers to the system of appointing and removing the judges that has emerged as a result of Supreme Court decisions rather than the acts of the Parliament. Okay, how its system evolved? So the Chief Justice of India advised on the judicial appointments and transfers can be declined on cogent reason according to the first judge's case of 1981. But for the next 12 years, executive has a priority over the judiciary in judicial selections. Okay, here in the case. But in 1993, what happened is the consultation was made compulsory. Supreme Court established the collegium system, concluding that consultation required the consent. Consultation means it is consent. The meaning of consent. So they interpreted that the consultation is same as consent. So it went on to say that it was not the Chief Justice of India's personal judgment, but rather than an institutional one made in the collaboration with Supreme Court, two more judges. That means Chief Justice of India, when telling in the name of the Supreme Court or on the opinion of the appointment, he has to refer the matter to at least two more senior judges. Okay, in third judge's case of 98, on the President recommendation, the collegium was expanded to 5-member panel consisting of Chief Justice as well as 4 of his most senior colleagues. So Supreme Court led by Chief Justice of Supreme Court and this collegium is led by Chief Justice and consists of 4 other seniors. High Court collegium is led by Chief Justice of that particular High Court and 4 other senior justices. Okay, so until the CJI and Supreme Court collegium have approved, and High Court collegium's recommendation for the appointment does not reach the government. Okay, so even the High Court judges must get the approval of the Chief Justice of India and Supreme Court collegium. This method is used to nominate the judges in the judiciary, and the government is only involved after the collegium has settled on the names. So it is very simple. The collegium will finally decide the names and just send to the president. So president, 3 or 4 names will be sent to the president. So president may appoint any 1 or 2 of them. So okay, see, if a lawyer has to be raised as a judge in High Court or Supreme Court, the government's participation is very, very limited to requesting an investigation by the IB, right? So what is IB Intelligence Bureau? Is a well-known and well-established it is an intelligence organization which works under the Ministry of Home Affairs. Okay, so if you see the various judicial appointment procedure, the President of India will appoint the Chief Justice of India. So whoever the senior, generally he will be appointed according to the convention. Okay, so general and the retiring CJI will propose his successors. So however, the seniority principle will mostly be followed. So in few cases the seniority principle was not followed, and which faces the controversy. Okay, so the suggestion is begun by the CJI for the other Supreme Court judges. So Chief Justice of India talks with the remainder of the collegium as well as the court senior most judges from the High Court where the suggested person sits. So finally the consultation have been done, and the collegium sends its suggestion to the Law Minister, who then passes it to the Prime Minister, who then, so through the collegium to Law Minister to Prime Minister to President. So finally the whoever will be get appointed. Similar is the case about the Chief Justice of High Courts, who are appointed in accordance with the policy of appointing the Chief Justice from the outside of their particular. So Chief Justice must be outside of their particular states. The decision on the elevation is made by the collegium itself. The collegium consists of the Chief Justice and 2 more senior judges of the High Courts. So is by outgoing Chief Justice of India in question in cooperation with the 2 senior colleagues. That means the outgoing Chief Justice of India will decide the next Chief Justice, India, not India, The outgoing Chief Justice of High Court will decide the upcoming Chief Justice. Okay. So the Governor is also advised to convey the proposal to the Union Law Minister and again to the Chief Minister. Okay, right? This collegium system is under the criticism. Why? Because first of all, no transparency, full of nepotism, no embarrassment in public discussions. So it is many times it got embarrassed in public debates. Several brilliant junior judges and advocates are overlooked. Reforms in appointment system have to be attempted. So the efforts earlier was done to replace the Collegium System with the National Judicial Appointment Commission, but it was struck down in 2015 because of it threats the judicial independence, which is a basic structure set by the Constitution. Set by the Supreme Court. So what about the provisions in the Constitution relating to the appointment of the judges are Article 124 Class 2. Okay. Next, and also in conjunction with Chief Justice of India and Governor of State. So under Article 217, so appointment of Supreme Court appointments under Article 124, and 217 deals with the appointment in the High Courts. So okay. So as far as possible, so it is impossible to put the time limit on filling the vacancies because already there are a lot of pendency and lot of vacancies. It's past time to consider the establishing of a permanent independent body. Yes, a permanent as well as independent body has to be established in order to make the appointments in judiciary. It should be a self-contained, diverse and displayed professional skill and ethics. Instead of deciding the number of judges needed to fill the specific number of vacancies, the Collegium must present the President with a list of possible candidates in order of preference and other relative criteria. Basically, this relevant criteria is completely absent. That means on what criteria the Supreme Court judges are being selected, no one knows. No one knows the criteria on which Supreme Court judges are being selected. Okay. So the reforms needed in the GST regime. So the relevance is an article was recently published in Indian Express titled "The Make GST Good and Simple." Good and simple. So wherein many recommendations have been given to how the GST regime can be made good and simpler. So the relevance is there must be growing concern regarding the challenges faced by GST regime. We all know GST Council also has to be taken many necessary steps. There are many implementation problems. Some long-standing demands like reduction in the number of tax slabs under the GST regime still continue to exist. Okay. So if you see, I think in the last week also we discussed these points about the GST. That is, what is GST, when it was implemented, and which taxes come under it, and how it is levied. Okay. So how it reduces the cascading effect and all. So unlike the prior taxes, GST is completely corrected at the point of consumption rather than the place of origin. Okay. So it is a comprehensive tax that replaces several indirect tax. It is tax that is levied at each stage of manufacturing process and is reimbursed to everyone except the ultimate consumer. Next, within the GST, three taxes apply: CGST, SGST, IGST, central, state, integrated. Who is responsible for which tax? Central charges CGST, state charges SGST, center charges IGST on the interstate trade. Parliament will pay the government for any losses. Central government will pay the state government in case of any losses. Okay. If you see, these are the taxes which have been subsumed under GST. Next, these are the state taxes and these are the central taxes which are subsumed under GST. Negative consequences is 14% excise fee is there by the federal fee is imposed by the federal government. Roughly 29% of sale tax imposed by the state government. India is one of the world's fastest growing aviation markets, but the industry is beset by rising the debts. The real estate sector is also, so here real estate sectors in expert believe that the GST has increased the cost of real estate sector. Okay. So why? Because 8% was the demand, will increase it to 12%. GST has not yet been stabilized, and there are also compliance issues, several complaints about the procedures. Okay. And the structure of present GST system is as follows. GST was implemented to simplify the taxation system. It absorbed several state and federal charges. Essential commodities are tax free. These are the slabs mentioned. 28% tax compensation tax on sinful items were given. Sinful items means like tobacco, cigarette, gutka, alcohol. Exporter receives special cheap prices on precious stones like jewelry and other supplies. So there is a need for resetting the GST and making it good. Okay, so like it has been having too many tax rates, so tax rates have to be reduced. Okay, so GST regime's fast start and rate settings issues are there, and also system has to be stabilized as soon as possible. GST, despite the fact that the GST collections are strong, income has fallen short of the expectations. So GST Council must propose reforms for the tax slabs and also create the blueprint for the improvement of near, medium and long term. Now coming to the study, the National Institute of Public Finance and Policy has published a report proposing 3 rates, only 3, 8, 15, 30, that's it. 18% rate now generate more taxable revenue. Even insurance premium are subject to this tax. So if 18% slab is decreased and merged with 12% slice, then income will be lost. This would have been countered by the increase in the lowest 5% to 8% and highest 10%, that is 28% to the 30%. So first of all, they are recommending a 3-rate approach. So as far as possible, the administration must decide on GSTs. So now that the GST is in its 5th year, it's time to alter the rates. 3-rate framework plan has to be set up as far as possible, and new taxes have to be implemented. GST Council must also address the issues identified by the NIPFP. Okay, restructuring of GST rates must be done. Government should also take steps to include the electricity and aviation fuel under the GST. Okay. So this enables the quick response and resolution of GST related issues. It will show to be a successful tax system in the long run. Okay. Yeah. This is all for today. Thank you.